I will now turn it over to our main event. This is Lisa Magill from our Pompano Beach office, and you're in for a treat because not only is she a rock star in the industry, she's one of the very few board certified specialists in condo and plan development law in the entire state of Florida. There aren't many of them. We have one today. Lisa, the floor is yours, my friend.
Mhm. Well, good morning, everybody, and thank you for attending this morning. Thank you, Jeff, for being so laudatory. Today, as Jeff explained, we're going to talk about basically the update from the 2025 legislative session. 2025 legislative session. So if you've
It's
done your
confusing.
4 year, if you've done your board certification, which is the 4 hour class, then every year thereafter, you need to take a 1 hour update. This is the 1 hour update. I think the updates go from July 1 through June
June
30.
30th.
So we're on the July 1 through June 30, and then on July 1, we'll begin a new update. Although next year's update is going to be pretty boring because nothing really happened in the legislature this
It'll be a
particular
high and a buy. The
session,
class will be three
right?
minutes long.
Yeah. Well, yeah, and you know what? And we'll talk about other things. We'll talk about other advancements or changes that have occurred as a result of different cases that have been announced, and we'll just maybe do a little bit of a primer on some of the things that we see problematic with some of our clients over the years. But again, today we're going to talk about what happened in 2025. So let's begin. I don't have control.
Yeah, let me get those slides open.
You kind of give me control, or you're not sure?
Let's see here. I'm not sure.
Okay, I'll let you go forward. Okay, I'll
There
let
you
you go
go.
forward. So the first thing we're going to talk about. So last year's legislative session, it could be divided basically into three different major categories, but most of the categories are, we don't trust you. We don't, you meaning volunteer board members, leaders, community leaders. We don't trust CAMs, and we don't trust the industry, almost in a way. So there's been a lot of changes that make things a little bit more draconian, or how do you say, a little bit more rigid. So the first bucket of items I'm going to talk about relate to the CAMs, and those are community association managers. Those are licensees in the state of Florida. Community association managers need to have a license in order to be called a CAM, and also management firms require their own license to be a community association management firm. So, as a result of some complaints that were made with the legislators over the years, now the law specifically says is that someone cannot obtain a CAM license, own or work for a management company for 10 years once their license is revoked. Um, and the contract with your community association manager or your community association management firm has to contain certain professional standards language. That doesn't mean that if you're in the middle of a contract that you need to go ahead and immediately modify your contract. But when you do renew, I suggest that you modify the contract to include not only the professional standards language, but some of the requirements that you're going to see on the right side of your screen, and that's the CAM meeting and contact requirements. These requirements were initiated for homeowners associations a few years ago. Now they are applicable to condominium associations. So for the CAM and the contact requirements, a CAM has to attend one association meeting in person every year. There has to be notification to the owners of how you can contact the CAM or the community association manager that is responsible for the management of your community. So if you're working with a company and the company has assigned a particular manager to your account, if you have a website, that information should be on your website, not with the contact's name, your manager's name, your email, phone number, and any other way of contacting them. The law specifically says that the owners are entitled to a copy of the contract with the CAM, but as you well are aware, the official records include all contracts for which the association is a party. So owners are always entitled to review association contracts. Another item that added, you can move on, but another item is that the CAMs will all have online accounts that where the state can see which properties that they work for. Here's another of the trust issues, conflict of interest disclosures. You're going to see this in more than one area, but for community association managers, there is a more robust, let's just say, disclosure that's required. You probably have in your management contracts, if you're working with a big company, at the last page or one of the very last pages, there's a big old paragraph that says, we work with the following companies, or we have a relationship with the following companies or individuals for which there could be a benefit. And that is the exact same thing that you are going to see going forward. They have to disclose any persons or companies or service providers which they have a beneficial relationship. So that way, if you are obtaining bids from those companies, then you also can require, and the CAM is required to present you with a bid from a company for which the management company or the manager does not have that same beneficial relationship if the contract exceeds $2,500. So that way, you can compare apples to apples. You may be getting a better deal because of the relationship that the management company has with the service provider. You may or may not, but you want to be able to have that ability to compare the services, the products, and the fees associated with those services between a company for which the management has a relationship and those for which it does not have a management or other relationship. And if the management company or the CAM is going to provide services other than community association management services, there's a presumption of that conflict. So therefore, obviously, you need to have that disclosure. Now, these disclosures should be all over the place. Number one, it should be in the contract itself, just like I told you, that big paragraph at the end of the contract that says, we work with this bank, this landscaper, these insurance companies, or what have you. It should also be on or something, if you're going to have a relationship with one of the other entities, there should also be something either in the contract with that other entity, before you enter into a contract with them, if it's a restoration company, if it's an elevator company, whatever it is. And really, it should be either on the agenda for the minutes, the agenda for the meeting. So conflicts and professional conflicts need to be disclosed on the meeting agenda and included in the minutes of the meeting at which the association, the board of directors, decided to go forward with that other contract or that other relationship. So undisclosed conflicts, what if you find out later that there is that relationship of which you were unaware, then the contract is voidable, meaning that you can get out of the contract without having to pay any penalties or without having to suffer any adverse consequences. I see a question right here, competitive bidding at 2,500. No, you don't have to have competitive bidding for all services at the $2,500 level. It's 5% of the annual budget is what it says in the statute. I'm saying that if a management company has a relationship with a particular vendor, just can pick one, water extraction or property restoration contractor. So they're going to present you with a contract for work to be performed by that company. If the value of that work exceeds 2,500, they need to send you, or they need to provide you with a bid from a company for which they do not have a relationship with. Now, remember, a lot of this is also dependent upon emergency situations. So if there is a pipe, that's bursting and there's water rushing all through your condominium, well, and they call a plumber, and the plumber happens to be one of the plumbers with which they have a relationship, that I wouldn't be that worried about. But if you have a pump that needs replaced or something that is not necessarily an emergency service, and you have the time to be able to review these bids, go ahead and review the bids. Now, with the CAM contracts, it's not all the responsibilities are on the manager or the management company. There's also obligations on the part of the board. From the board's perspective, you have an obligation to verify that the people which you're dealing with have the appropriate licenses. Now, this is in the statute when it comes to community association management contracts, but it applies to all contracts. If you're entering into a contract with elevator maintenance firm, you're entering into a contract with a restoration company, a contractor, whoever the service may be. If they're required to be licensed, you have an obligation to ensure that they do maintain that license. Also, a remedy that you have as a board of directors is you have the right to terminate either your manager or your management firm if the license is suspended or revoked. So you won't have any adverse consequences for terminating a contract with someone that has lost or their license is suspended. And the same thing is true if it's with the firm or with the individual. Now, there was a question here about it's related to disclosures, which related to complex, but it's not really related to exactly this particular law. And the question is whether a CAM or community association manager can also be a real estate agent and sell condos in the building that they are managing. Now, if that manager is your employee, you're the board of directors of the association, and you employ the manager directly as an employee, you can make the determination to say, hey, if you want the job here as our CAM, as our full-time CAM, you are precluded from engaging in any individual business in the building with regard to sales or leases on behalf of individual owners. But that is a decision that the board of directors can make because they want to avoid the appearance of impropriety, or they want to avoid any type of notion that there is inside baseball going on because the manager will have more information about who wants to sell or who wants to move, or what properties are coming up for rent. But that being said, if you as a board of directors do not believe that it's problematic for the manager to perform services for individual owners as a real estate agent or as a leasing agent, then that's something that you don't have to preclude. It just needs to be perfectly clear that then when they perform those services, they're doing so on behalf of the individual owners and not the association. So it has to be very clear to both the owners in the building, the manager, and any third parties that that work is being performed by that person as an individual, not as a representative of the community. So let's move on to the next slide. This is one of the most important things. Now, you probably already heard this because it was enacted and went into effect of July of last year. Everyone's holding conferences via videos, and we're doing it right now. But video conference meetings, whether they're board meetings, whether they're membership meetings, whether they're the annual meeting, even if you're handling committee meetings via video conference, like a Zoom type of a platform, means that it needs to be recorded. The actual conference needs to be recorded, and those recordings maintained by the association for a period of a year. If you have a website, either the recording or a link to the recording has to be posted on your website. And that's a very big change from the past, because in the past, even if you did have audio recordings of your meetings and you were making them for the purposes of helping you create your minutes, then you did not have to retain the audio recording that itself. Now, it doesn't matter if you're just using the video recording solely for convenience purposes, or video for convenience purposes, or to enable other people to participate. The video itself must be recorded and the recording made available to the owners on your website or in some other way. And that goes for as I said, for the annual meeting and and all of your committee meetings and all of your board meetings, including your board budget meeting. There's also something on this slide that talks about voting via ballot, um, by mail, by emailing, and I'm going to talk about a little bit more about that later. So we're not going to really talk about that right now. There's a question here about is there a special category for a CAM that doesn't manage a property? No, the CAM license is the CAM license, and there are various professionals out there that have CAM licenses. I think Jeff, don't you have a CAM license? The second that he turned
Yeah,
off
that's
me
it.
when I
Sorry,
asked him.
I'll put the share back. But yeah, mine ran out recently, but I had one and just was inactive as a manager. But I kept the license active for several years. So
Right, exactly. So a
yeah.
lot of people that are in the industry, either collaterally, I'll see vendors or the other service providers, even people that have painting contractors or other types of services. They want to obtain the CAM license because they want to understand what the requirements are for associations so that they have a better understanding of how to work with an association. And in a lot of ways that it's good because you won't have those individuals undertaking actions that knowingly is in violation of the statute. So one of the things that we hear often is that you had contractor meetings in private, and the contractor met with the two or three, or even the majority of the board members that the contractor knew were supportive of them, did not meet with the two, three, or other minority directors that did not support them, and lo and behold, you have a signed contract without an open meeting and without any notification to the other directors. That's obviously a bad thing. Could be voidable, and it depends on the circumstances. But you want people that will understand what the legalities are of working with a board of directors.
Hey, before you go on, Lisa, just a reminder to everybody. Please do not put your class material related questions in the chat. Use the Q&A module. Two different things. The chat is just for technical issues and also where we're going to place the evaluation link later. So Mark, Martin, and a few others, take your questions and please put them in the Q&A and not in the chat. We are not monitoring the chat to answer questions about the class material. Back to you, Lisa.
Thank you. Thank you. Yeah, I see a lot of questions in here, so I want to take a look at some of them. Questions very, very good by Ms. Turner. Does Zoom with the video turned off count, aka sound but no video? In my opinion, if you have only an audio component, meaning there is no video component to your meeting, then no, it's not a it's not a video meeting, and therefore the statute does not apply. That being said, the proposed rules that I saw published by the Department of Business and Professional Regulation attempt to define any remote meetings, regardless of whether there's a video component, as a video conference meeting. Those rules have not been adopted yet, but I do want you to be on the lookout, BOLO, for any announcements that are made, because at some point we may hear that even if you don't have a video component, those are considered video conference meetings. And if there's a video capability, even if the video capability is not turned on, so you don't want to run afoul of the law if that actually changes. And another question here is there a requirement to videotape all meetings, the ones that I talked about? But then the secondary question is, what about the closed board meetings? And again, there's no specific regulation on this, but I would say no. So when you have closed board meetings, that's very, very limited. You only can have closed board meetings if meeting with counsel to discuss legal issues, legal liabilities, or if meeting to discuss personnel issues. And when you do have those closed meetings, you still have to post notice. You have to within the time constraints of the statute. So if it typically would be a 48-hour posted notice, and you still have to create minutes, but the minutes are not going to contain really any of the detail. It will simply say who was there, the time the meeting was called to order, the purpose of the meeting, the fact that either personnel decisions were or personnel issues were discussed, or meeting with counsel to discuss legal issues, and then the time that the meeting was adjourned. So those minutes are important to have. Those notices are important to have, and even though the owners are not required to attend, I have not been aware of any administrative complaints or announcements from the Bureau of Compliance with respect to this issue, but I personally have said to clients that no, if it's a closed board meeting, there's no need to have a video conference, because the video conference is not going to be available to anyone. What's the biggest issue that we have with community associations, both condos and HOAs, but it's far more frequent with condos than it is with HOAs? It is official records and access to official records. So there are some official records that now there's an extended timeline to maintain. Minutes, now you must maintain them indefinitely. That doesn't mean if you don't have minutes from more than 10 years ago that you're automatically in violation. You weren't required to have those minutes for that period of time 2 years ago or more than 2 years ago, but from now on, please maintain those minutes indefinitely. And here is what I suggest when it comes to minutes, because the meeting notices are almost important as the minutes, depending on what activity takes place at the meeting, as is the affidavit of mailing. So I always talk about minute books. We don't have physical loose leaf binders anymore, possibly with the minutes and the meeting notices. But if you have a book or a file in your computer, what I always suggest that you have the meeting notice, the affidavit of mailing, if there was an affidavit of mailing that was required, any of the contracts, obviously, that you're going to be discussing at the meeting, along with the minutes, all saved as one file. So that way it's all together. This is really not only important when it talks about what contracts did you enter into. It's really important, obviously, for special assessments, because if we need to collect a special assessment, we are going to have a copy of the notice of the meeting and the proof of notice of the meeting, the fact that it was mailed out or mailed or distributed to the owners at least 14 days in advance. But you know where else it is also very helpful? With amendments or changes to rules. One of the arguments that you can get in response to a rule enforcement action is, hey, when did you adopt this rule? And I want to see minutes of the meeting showing that you properly adopted this rule. So if you have all that documentation together, it's easy to locate. And if people say, where are your minutes? You can have, if you have a website, which all of you with 25 units or more are now required to have a website and have all of your documents posted to the website, then it's easy enough to say, hey, go ahead, look at the website. There's no reason to make appointments to come in or have any machinations back and forth with the owners over access to those records. The statute was changed. Now, again, let's go back for a second. The statute was already also changed to say that financial records include bank statements, ledgers, invoices, and transaction receipts. So I know that you have those. It's no longer appropriate to say, here are our financial statements, and only to provide the financial statements that may be on the public portion of your website. If people ask for those specific documents, you have to make those specific documents available. And when it comes to your website requirements, in the past, people would say, well, how long do we have to post things on the website? Obviously, if it's meeting notices or something before a meeting, it has to be posted within the time constraints of the statute. Now, for everything else, it's within 30 days, of creation of the actual document. So let's move forward. I don't want anyone to get alarmed by this, but yes, there has been an attempt, well, there's been a successful attempt to criminalize certain portions of condominium operations. So with respect to records access, now the statute says if violations, meaning you fail to provide access to records, you fail to maintain the records, you fail to engage in a good faith effort to obtain records that have not been maintained or that are not currently archived within your within your systems, willingly, knowingly, and intentionally, then that can trigger criminal sanctions or criminal penalties. I don't want any of you to be worried. You do as best as you can, and you keep the records in as orderly fashion as you can, in a manner that you believe is orderly and accessible. Then you won't be challenged with any of these crimes or criminal penalties. You do have fiduciary obligations to make sure that everything is transparent within your community and that owners do have the ability to access these records. You're still going to get complaints. The records aren't exactly the way that I would maintain them, or you didn't do the financial reports in this fashion or that fashion, or the contract that you posted is inadequate in some way. But so long as you have the actual records, those are your actual records. When it comes to your year-end financial reports, a little bit of a breather on the part of the accountants, because now the deadline is extended from 120 days to 180 days from the end of the fiscal year. So okay, gives them a little bit more time to get those financial reports prepared. But for your purposes as board members and volunteer leaders, please make sure that you contract with your auditor before the end of the fiscal year for which you want the report prepared. So right now, this is 2026. Why can't you contract right now for your 2026 year-end financial report? Hey, who knows? It's only March. Maybe your auditor can do some of the advanced work in between April and December, so that when January rolls around, or actually February, because we have to wait for everything to be reconciled, when February rolls around, they have less work to do and can actually produce your report faster. Also, that gives them the opportunity, and you and they and the opportunity to locate documents that may be necessary for the year-end audit before February of the following year. When you're scrambling around, you may have your annual meetings then, you have all kinds of things to do then. So why not talk to your auditor and enter into that contract now? Because many auditors will not have the capacity to even take contracts after January, February. They've already contracted with all the associations that they have the ability to perform the report for. And you have to distribute the report. The law says right now you have to do both. You have to do the postcard saying the report is available, and you have to deliver the report. But if you have permission on file to use email for official notices, beautiful. Go ahead and just email those reports out to everyone. I mean, you can also send them via US mail or hand delivery. Obviously, email is a much more effective way of distributing things. And then you can still reduce the level of financial reporting. The vote has to be taken in the year for which the financial report is produced. So right now it's 2026. You can vote now to reduce your 2026 year-end financial from an audit down to a compilation, if you so desire, but that's only a 1 year option. So the next year you have to produce the report that is required based upon your level of income. Most people find it's hard to say. It depends on the sophistication of the financial operations of your community. Some find that contracting for 2 years worth of audits can be even more cost effective than contracting for the one audit, then skipping the year, then contracting the next year for the audit, because there's a lot of work that needs to be done in between year 1 and year 3 by the auditor. I can't really answer that question, but it's definitely worth talking to your auditor and finding out whether or not that's appropriate for you. Here's a good question. If we're having an in-person meeting, do we have to offer video conferencing? No, it's a convenience. You don't have to offer audio or video. And for your board meetings, you have the option, should you so desire, of allowing your board members to attend via telephone conference without extending that offer to your individual owners. So that's really up to you. Now, having these options has made life, I think, a lot easier. It's increased participation. I know that it's increased participation. So I think it's a wonderful thing. And it's just a matter of you making sure or taking steps to minimize any banter on a video conference that could otherwise be problematic in the future.
Hey, Lisa, while you're doing that, I just want to mention something because you talked about email earlier, and there's going to be an inevitable slew of emails that we get when we email the certificates out. When people, even if you, when you sign up to receive official business emails from the association, keep in mind it is your responsibility, the owner's responsibility, to make sure you can access those emails. So if they end up in spam or some kind of weird deliverability issue, it's not the association's responsibility. It's your responsibility to make sure you can get those emails. So always keep tabs on your spam and junk folders, your different alternative tabs in your inboxes, because you never know, with algorithms changing all the time with Gmail, AOL, all these organizations, you never know where these emails are going to end up. And that is not the fault or the responsibility of the association or the management company.
That's that very true, very good point. And recognize that if you consent as an owner, if you consent to email as an official means of communication, that means your email address goes on the association's roster and is available to other owners. So what I suggest is, hey, create a special email that you use for association purposes so that if you have someone that obtains access to all those email addresses and starts sending out spurious emails or emails on for sport on a daily basis, well, you really don't have to check that. You can weave through those that one particular email address to look for those that are emanate from the association and then weed through all the other ones. There's a question, well, let's move on to the next slide, but there's a question here about what does an affidavit of mailing look like? An affidavit of mailing is exactly that. It's someone or affidavit of distribution of notice because you're emailing or however you're distributing the notice. It's exactly that. It's I, Lisa Magill, or whoever is actually effectuating the notice. So it could be your manager, could be a staff member, could be anyone. Hereby state that I put notices of the meeting for the budget to be held on April 17 in the mail on blank day. And that way it shows that it went out 14 days in advance. It's just an affidavit basically saying, and that's a notarized document. So it's just a document basically saying when the meeting took place or that you're verifying that the meeting notice was distributed. So for the budget meetings, same thing. Again, you need a 14-day notice. A copy of the proposed budget needs to go with the notice. The budget meeting can be held remotely via video conference, should you so desire. The 115% rule changed. Now, I don't really think you need to worry about this a whole lot either. There's been a 115% rule in the statute since I've been practicing. In the past, the rule said if the budget went up by more than 15% from the previous year, 115% from the previous year, then the owners could petition to have an alternative form of budget adopted. And back then, the owners had to actually prepare the alternative form of budget. The meeting notice would go out, and you needed a majority of the entire membership to vote for the alternative budget in order for the alternative budget to go through. Now, if the board adopts a budget that goes higher than 15% from the previous year, it also has to, it's on its obligation now. The obligation has transferred from the owner to petition to the board to create an alternative budget that eliminates discretionary expenditures. Discretionary expenditures. That's exactly what the statute says, discretionary expenditures. Now, most budgets do not contain discretionary expenditures. Maybe every now and then there could be something that could be considered discretionary, like entertainment expenses, if you're allowed to have entertainment expenses, or maybe renovation expenses. But even renovation can be considered maintenance and repair, and maintenance is required. So that's not really discretionary. Well, alterations and improvements. So, but alterations and improvements, depending on your condominium documents, require the approval of the members. So at that point, are they really discretionary? No. When you're calculating the 115%, you exclude reserves. You always exclude reserves, and you exclude insurance premiums. So those are your big ticket items that usually are very well. A reserve should be planned out and anticipated at this point. Insurance is just unpredictable. Now we're actually coming into a period where insurance is a lot more palatable. The rates are getting a lot better. The coverages are getting a lot better. But remember 5 years ago when you could have 100%, 200% increase and not even know why, and has nothing to do with your property. Well, you have no control over that. If to adopt a substitute budget, again, it's a majority of all the voting interests. So I doubt that this is ever going to happen. While in the past I did have communities where the petitions were presented and even went through with the meetings, there was never was a situation where the budget as presented by the board of directors didn't go into effect because you didn't have a majority of the members voting in favor of a substitute budget, and because the expenditures themselves are not really discretionary. They're expenditures that you have to have. Let's move forward. I talk about the budget continued. Multi-condos, if a multi-condo is where you have one association operating several condos. If you're in Broward County, the Sunrise Lakes properties are like this. There's many properties throughout the state of Florida where there's one association operating more than one condos. Obviously, in those multi-condos, unless you've consolidated financial operations, you're required to maintain separate budgets. But that's just one big budget with all the little subsections. So condo A, condo B, condo C, condo D, and then of course there's a section of your budget for all the expenses that A, B, and C share together. And this year, for some reason, well, at the end of last year, it's getting a lot of questions about rollover of surplus funds and whether that required a membership vote. I'm going to ask you to consult with your CPA with regard to that, because that question is really more of a tax issue than it is an association issue or a Florida condo law issue. For condo law purposes, you can roll your surplus funds into the next year. You can use some of those surplus funds to maintain working capital. You can use those surplus funds to reduce the amount that you need to budget for the current year. But remember, the law does require you to adopt the budget 14 days prior to the end of the fiscal year. So make sure that you start working on it early. You get your notices out early. I know a lot of associations sometimes adopt their budgets late. You really want to get out of that habit because of the way that the law has been changed. Okay, there's a question here. So I'm going to keep on the slide, but there's a good question here. How can I disclose on our website when it includes the liquid accounts and all checks are paid out? This is why I say from the public part of the website and the private part of the website. When I say public, I don't mean public to the world. I mean public to your owners. So if I'm a stranger and I go to your website, I might be able to see some pretty pictures. I might be able to click on an icon that says and tells me who the members of the board of directors are. I might be able to click on an icon, tell me, when, alternative day street parking or what have you, but I'm not going to be able to get the financial statement. So the owners are going to be entitled to get all your financial statements, but those generally exclude items that are of a sensitive nature, like checks. I mean, you're not going to have your signature cards on the website. You're not going to have sometimes your bank statements themselves on the public part of the website because you have all the ACH codes available, and you're not going to have maybe your own checks because you have some of that distribution information. But if you do receive a request for those documents, the association is required to produce those documents, including individual ledgers showing owner delinquencies. So whether you put them on the website or you make them available, accessible on the website, that's one thing. Whether you have an office and you print them and you require people to come to the office to review them, of course, they can obtain a copy, but those documents are definitely available to the owners, have to be made available to the owners, and to the extent to which you desire to redact them to try to preserve some of your information, is your own. Now, if there's any personal identifying information of the unit owners, like credit card numbers, I don't think you have them on your ledgers, but you may have account numbers or other items that could expose that individual member to loss. You're going to want to redact that information. Even emails, you need to redact email addresses that are not public when people come to review association official records. So let's talk about electronic voting versus email ballots. The new law, not new so much, it's last year, but the law says if you don't have electronic voting at all, let's just say there's no electronic voting, you've never adopted it, you've never used it, and you're coming up to an election or another type of vote. Really, the way the statute appears that it really talks about elections, let's just use it for any type of vote. You, as an owner, can waive all the secrecy that's associated with putting the ballot in an envelope, putting the envelope in an outer envelope, signing, sealing, and sending the outer envelope to the association. You can, if you want, just fill out your ballot. It has to have your name. It has to have a certain disclosure on it, and then just email it to the association. It's perfectly countable that way. On the association side, you have to designate an email address for owners to send these emailed ballots. So you might want to set up balloting at Happy Land Condo. So that way, immediately prior to the meeting, you can go right to that email address, print any of the ballots where people have submitted them with their names, with the disclosure, knowing that the vote is no longer secret, and you utilize them, include them in the tabulation of the election of directors or whatever other vote is being effectuated by the members. If you have electronic voting, you don't need to do that because people can just go on and vote electronically. If you don't have electronic voting and the owners want electronic voting, then they can petition for electronic voting. So the petition have to be served within 180 days, within 6 months of the annual meeting. And the board within 21 days will need to meet to decide which voting platform to engage. That still leaves it up to the board to decide what platform to utilize. So at that point, you're going to have 21 days to sign up for some demos, figure out which is going to be the easiest one for you and for your members, and then notify everyone how they will adopt the resolution saying which platform you're adopting and how they opt in and how they opt out, and then notify everyone individually what they need to do if they want to vote electronically. So there's a difference. Electronic voting and email ballots, they're not the same thing. Email ballots just means, hey, it's the day before the election. I never mailed in my ballot. I'm in Arizona. It's never going to get there in time, even if I try to FedEx it. So I'm going to fill out my ballot. I'm going to have all the disclosure information on there. The association should tell you what that is, or prepare an alternative form of ballot that you can email, and then you can go ahead and email it in. You can get that email in half an hour before the meeting starts. So it's a good option for you if you don't have electronic balloting. Electronic voting, again, we'll talk, this is what I basically just said, but the board chooses the vendor, the board adopts the resolution, and the platform has to be able to authenticate the owner identity, has to be able to authenticate the validity of the vote, has to furnish a receipt to the voter, has to store it, obviously, and for elections where the voting is secret, has to separate the vote from the identity of the voter. The board does not know how you voted in an election if you vote electronically. The management does not know. The attorney does not know how any voter voted if you voted electronically. Please do not be concerned about that secrecy. The statute also says is once you start with electronic voting, you have to continue with electronic voting. It doesn't have to be the same vendor. If you want to switch vendors, you certainly can do so. So you have to go through this process again, unless everybody decides they don't want to vote electronically anymore. I think it's fantastic. I think it's so easy. I think it really makes a huge difference in your operation. So, Jeff, what's your experience with electronic
No,
voting?
it's I'm with you, and I just want to throw my 2 cents in because somebody earlier asked a question about board members running their own websites, and there are so many plugins. Websites are easy to create these days with these plug and play options that are simple to do. But Lisa mentioned vendors, and it's always better to use. It's always best to use vendors that specialize in this and only this because again algorithms are always changing and you don't want to put your association at risk by trying to implement something yourself and then algorithms change and all of a sudden identities become public when they need to stay private. You should never try to do this yourself. Just wanted to throw that out there.
Well, definitely not for electronic voting. I mean, for
Right.
websites, it's a little bit different, but for
Right.
websites,
I
the
just meant
owner of
electronic
the
voting. That's
website
also I
has to
meant.
be the association. This is really, really important
Right.
because if you have someone individually sign, all no nefarious intent at all, they just do it for you. But then what happens if that person is no longer available? Or what happens if you get into a dispute with that person? Now, your website and all the content on that website is belongs, even though it really does belong to the association, the person who established the website. You want to be very fluid. If there's something with a website, whether you're working with a company, you want to be able to transfer all that information to another website. You want to be able to have more than one person have access to upload items to the website, and you want to have those passwords
Right.
readily available so that other people in the office or other directors can get access. I know
Bottom
that
line is this, because Lisa's 100% correct. Uh, keep when you provide the records, if you're using a third party vendor for a website, keep digital copies of the records you're giving to them somewhere else. So you can create a free email address like Lisa mentioned earlier. You can create a free storage account on Google, password protected, to keep all your records, for example. So keep those records. So if there is some kind of a falling out, you're not struggling to get records back for the new website. All right.
Okay, so milestone inspection updates. Okay, I'm going really slow. I didn't realize how slow I was going. So let's talk about the milestone inspection. Really hasn't changed much. Really, the only thing that changed on this is that it's now defined as three habitable stories. So in the past, it was three stories, three stories. So you had one ground of parking and then 2 stories of residences. That required the milestone. Now it's only three habitable stories. So you have to have three different stories of habitable floors. But here's where we come to the trusting issue again. The inspector needs to disclose whether or not they intend to bid on the repair work, and the bidder must disclose whether or not they have a relationship with the inspector. So if you hire an engineering firm to perform your milestone inspections, sometimes engineering firms have embedded concrete construction firms. Sometimes they're build design firms where they have a design element. Those are all your engineers, and they have a build element. Those are all your contractors, and that may or may not be a good thing for you. It just needs to be disclosed because you need to know, the owners need to know whether or not, what's the relationship between the person or entity conducting the inspection and the person or entity actually performing the work. And the cities or the municipalities need to report a whole host of information over to the state. The state is compiling this information on the value of the permit, how quickly the work was done, how many phase two reports there were. So at some point we'll get a report showing some of this information. So let's move on. We're going to talk about the CEUs updates too. Reserves and CERS funding. So CERS are reserves. Those are structural integrity reserves or reserves for structural integrity components. So for CERS purposes, the quote regular or typical way of funding the reserves would be as the same periodic basis as you fund your regular assessments, your annual budget. So if you pay monthly, the reserves will be paid monthly. If you pay quarterly, the reserves will be paid quarterly. There the law does allow you to fund those reserves via special assessment, loan, or line of credit. Uh, but to do so, that requires a vote of the membership, a majority of all the voting interests in order to do that. And special assessments may be appropriate if you're trying to catch up uh, because you're behind on your reserves, and loans and lines of credit may be appropriate for the same reason if you're either trying to catch up or you're in the middle of a very expensive project that is being funded. Those are not the loans or line of credit. Borrowing to save is not something that I suggest or believe is a really good thing. Pooling, if you haven't pooled your CEUs reserves, you can do so without a vote of the owners. And if you still have money in straight line reserves, any of the CEUs components, so like the roof, or waterproofing, railings, you can put all of those straight line reserves into a pool. You can't combine the CEUs, the structural integrity reserves, pool with the non-structural integrity reserve. So you have two, if you want two pools, you can have two pools. One's for structural integrity, one's for everything else. And that is what everyone traditionally recommends. You can also fund or pause your funding if the building is declared inhabitable due to a natural disaster, or up to 2028 if you're funding milestone repairs. So you get a milestone report today, it says you need $2 million worth of work. For that next period, or up to 2 years, while the work is being performed, while the milestone work is being performed, you can pause the CEUs funding. Please check with both your accountant and your attorney to make sure that you're doing that the correct way. You don't want to be accused of failing to fund reserves because for a mistaken belief. Let's move on. So everyone in the past, full funding. What does that mean? Does that mean we have to have $10 million in the bank? Full funding is now, it's called baseline funding, or baseline funding basically means that the reserves never go below zero. So you're collecting enough money every single year so in the year that the work is performed, you'll have enough money to do that work. So if your roof is a 2028, needs to be replaced in 2028, by 2028, you'll have enough money in that pooled account to replace the roof. And by replacing the roof in 2028, paying cash for it, you're not going to go below zero in your reserves. So you're not going to go to zero because you're going to have reserves left over for whatever's going to happen in 2029, 2030, 2032. Obviously, the CEUs and the non-CEUs are itemized. In the study, many of the reserve providers are just preparing two different studies. In the past, they would include everything in one study. Now they have a CEUs study and a non-CEUs study. That makes it really, really easy for you just to plug in the funding number in your budgets, and you can plug in the CEUs number and plug in the non-CEUs number, funding number, and the members can still vote to waive the non-CEUs funding. Again, reserve providers also have to disclose whether or not they're going to bid on any of the work to be performed, and any of the bids submitted by a person or entity with a beneficial relationship to the reserve provider must likewise disclose the relationship. And if you're going to use loans or lines of credit or anything like that, it also has to be disclosed in the study. Here's something that people don't really think about. You can stay on the slide, is that if you deviate from what the plan says, so you have a plan today, but then lo and behold, you wind up having a surplus from a special assessment or a surplus from something else, from an insurance recovery or what have you. You say, oh, we got this extra 50 grand or 100 grand. Let's put it into reserves. Well, that changes your reserve funding schedule. So you have to go back to your reserve provider and have them redo the schedule based upon your actual situation. Same thing is true as if you're going to delay doing work for a year, which which under the way that the statute is written is discouraged. Or if you do work early, your whole plan is a little bit askew. So you just go back to the provider, they modify the program to reflect the actual circumstances, and then they give you the new reserve funding requirement. So you want your reserves to match your reserve study. Investment of reserves funds, they really didn't make any changes. This year, there were a lot of different proposals. Last year, there were a lot of different proposals, very, very complicated on how you decide on what financial advisor to use, how you create a financial plan. For now, the law does allow you to engage in various investment options, and you're not limited on the types of financial institution. But I would encourage you to take a look at your governing documents, because a lot of especially the older bylaws will say has to be an FDIC insured account in Broward, with locations in Broward County, or a Florida federal bank, or a federal bank registered in Florida, or something like that. So you'd want to make sure that you're not going to be investing in Morgan Stanley when your bylaws say that you're limited to certain types of financial institutions. If that's the case, then I would suggest go ahead and amend your bylaws. You don't want to be that so limited on your investment options. But of course, you have to play the role of the prudent investor, so you're not going to put any of the association's funds at risk. That just goes without saying. Let's move on. Online accounting resources. This ship has sailed because you were required by October of last year to make sure that the DBPR had all kinds of information about you. If you're watching this and you haven't done it, or you're not sure if you've done it, when you receive the program, these should be active links, and you can go on and check the links to make sure that you've done everything appropriately. This is not technically included in your 1 year update or the 1 hour update, but I do want to mention it. And it's not really necessarily important for you as members of the board of directors, but it is important for you as owners. And that is that all flood history must be disclosed in connection with the sale. It's very, very important. The term flooding is defined very broadly, and this is especially true if you have obtained any insurance proceeds as a result of a flood loss. And then the pilot program, it was extended a little bit. One of the changes, well, first of all, you have to be like white on rice in order to get in. But the changes include the vote to apply for a mitigation grant. The board of directors can decide to apply. It can vote to apply for the mitigation inspection. And once they get the mitigation inspection, at that point, you go to the membership to obtain the approval, 75% of the owners, to apply for the mitigation grant. And the program is going to be expanded to other portions of the state. And I believe going forward, the program is going to be expanded to prioritize income restricted communities that have a certain type of voting base. And I think is that. Oh, see, okay. And this is, again, here are all those active links. So when you receive this presentation digitally, you'll have the active links. And I'm sorry I went very quickly at the end, but I know that we have a couple of minutes for me to be able to look at these questions. Jeff, do you want to just make sure that everyone knows how to get their certificate and they're taking a look at the chat?
Yeah, let me just thank you for that, and well done, as always, my friend. So, if you haven't already done so, please press the chat button simply so the chat area appears on your Zoom interface. The chat is not to be confused with the Q&A module, two different things. We've already placed the link for the excuse me. I was hoping to get through it without a cough. So, we placed the evaluation link in there twice already. We'll do it again in a couple of minutes. So press that chat button if you haven't already done so. You're welcome to hang out for the Q&A. Lisa's going to go through and answer a few of them. We won't get to all of them. There's almost 500 of you here today, but she'll get to a few of the questions. After you fill out the evaluation, your requirement is over. You can go. Okay? So I repeat, because this question comes up constantly. You don't have to stay we want you to stay, but you don't have to stay for the Q&A. Just fill out the evaluation and you can go. Yes, the recording will be available on kbrlegal.com within a few days. And as we mentioned at the beginning, after you fill out the evaluation, there will be a confirmation submission screen of a successful submission. Let me show you that. Here's the evaluation. You click on the link. It takes you here. You fill this sucker out. It's not as daunting as it looks. It goes really quickly. And then the page after you submit it has this yellowish box that then appears. 4 bullet points: how to contact the firm, how to contact Lisa, our website, and then the last bullet: to save the slides from this webinar, you click on the word here, and there it is. There you go. You can then download them or print them. If you're on the phone and you don't see this, again, you go to our website, kbrlegal.com. At the top, there's a box for a certificate request. Click on that. And lastly, when we send these certificates to everybody, it'll be within 10 days from now, probably less, but up to 10 days from now. That email will come from seminars@kbrlegal.com, and it will also have, once again, it'll have the link to download the slides. If you can't figure it out now, that link will be also on the email we send to you with these certificates. Lisa, take a few of the questions before you have to head out.
Okay, great. So there was one question about what language is required for the email ballot. I'm going to try to put it. Can I put it in here? No. Yeah, it's not working there. But I did put it on the answer to the person that actually asked it. And if I can, I don't know why it's not working for me to put it in the other one.
Is the question? I can look it up on the answered section. Was it the one from in regards to voting via email?
Yeah.
You want me to just read it? It's a long.
No, it's long. I mean, if you could put it in where you can put it in the chat so that everyone can see it, that would be great. But yeah, there's a couple of questions here I thought were curious, that where the association has pooled reserves and now they want to unpool their reserves. I don't know why you'd want to do that, but do you need to have a vote then? Obviously, you'd have to have someone calculate where the funds in that pooled reserve should be allocated, and I don't believe it would require a vote because you're not changing. Well, and I haven't really even considered this issue because I haven't gone back and forth with it. But with CEUs, you're not allowed to change the purposes for which the funds are collected. You've collected funds based upon a schedule, that has the roof, that has the waterproofing, that has all the other components in it. So if you can have a professional allocate where those funds should be based upon your funding schedule, then you're not changing the purpose for which those funds are collected. So if you'd want to, you can go out of a pool and put them back into a straight line. But I don't know if that would be advantageous for you. There's also a question about the bank accounts. When I say 2 pooled accounts, that doesn't mean you have to have 2 bank accounts. Now, you have to account for them separately. Now, it may just be easier to have a separate bank account. One you label CEUs, one you label non-CEUs reserves. Same thing with special assessments. One you label special assessment pool, one you name special assessment roof, because it just makes it a little bit easier for you when you're paying your bills. You know exactly which fund to draw from when paying those bills, and when the funds come in, you know exactly which fund to put them in. But that's not required by any means whatsoever. As long as you can account for it separately, then you're doing things the right way.
And folks, some of you are more computer savvy than others. The file name of the slides has December 2025 on it. It's got nothing to do with the slides content. It's the same exact slides. It is only a file name. Do not worry. Lisa, back to you.
Well, yeah, this is 2025, but yeah, we're in 2026, but yeah, based upon the 2025 laws. Is that why? Is that what it is?
It's just the name of the file. That the link says 2025 in the link when you download the slides. So like, but it's the same exact slides.
Okay, so here's a question. And this has nothing to do with what we're talking about, but will be changes to the statute regarding renters, owners trying to get no animal condo, uh, emotional support animals into no animal condos? That's really, I don't see anything on the Florida level, and that's really more appropriately determined at the federal level. I do understand that the administrative agencies, HUD and their progeny are working on some updated guidance, and they have eliminated or they have revoked some of the guidance that was issued in the past. But I don't believe that there's been a concerted effort to make some of those changes. I am with you. I think that the way that the law has been really abused is a disservice to truly disabled people that are in need of the emotional support. So I would advocate for some modifications. Would advocate for some empirical standards to determine what constitutes the substantial impairment of the major life functions, so that it could be more easily evaluated by the association. Because again, you're not doctors, and even if you are doctors, you're not the doctor that supposedly treated, evaluated this patient. So if you have to rely upon a letter that looks like a form, I can tell you a personal story. This just happened 2 days ago, where there's two people applying to be tenants at a condo. The condo says the rules say that if you're a tenant, you're only allowed to have one pet. You're not allowed to have two pets. So both tenants applied for emotional support animals. It was the same exact letter. I mean, same exact letter, just different name on top and different name with the pet on the bottom. So, I mean, is that reliable? Is that sufficient? In my mind, that just is so suspicious that it really can't be given the credence that it should be. But what's the alternative to the association? We go back, and I do this so often, and it's very, very frustrating. We go back and we ask the owner or the person seeking the accommodation to give us a release so that we can talk to the provider directly. And then we ask the provider all different types of questions. And most of the times the providers provide very, very evasive answers. And again, now we're back into that same quandary. Do we have to approve it or do we not have to approve it? Some of the providers are great, and they will say, and we never ask for a diagnosis. We never ask for a treatment history. We never ask for, whether the person seeking the accommodation is on medication management or what have you. But you are entitled to know what major life activities are substantially impaired and how the presence of the animal serves to ameliorate those limitations. So I don't see any legislation coming immediately. You would think with this administration, they would be more inclined to relax some of those requirements, but it hasn't been done on any formal basis other than relinquishing or revoking some of the guidance that's been issued in the past. Here's a question I get a lot too, and the answer should be yes, but it's not. It is not at this point. Can the requirement for distributing the financial report be satisfied by posting on the association's website? No, you have to post it on the association's website, separate and apart from your obligation to distribute the report. But no, that does not count as the actual distribution.
Not
And
everybody's going to have the technology. That's the reason for that, you know?
well, right, not everybody has access to the same way. Not everybody will check and see that it's on there. And the email with a link to it is the distribution. So again,
It's the same
here's a
principle as
question.
oh, sorry, go ahead.
Here's a question I've never heard before. Can we force owners to vote electronically? No, no, no. So once you have electronic
Get
voting,
over here.
people
Do
have
it.
to decide. They either opt in or they opt out. So if they don't want to vote electronically, you still have to send them a paper ballot, and they still can vote by paper ballot. No, you can't force them. And then the question, is there official document to consent to communication via email? Some attorneys will create this big old long form for you and what have you. In my mind, if you get something in writing from the owner saying, I'm Lisa Magill, I want you to use this email address for all official association at mailings. In my mind, that's sufficient. You put that in the file, and I would put it in two places, actually. I would have a dedicated file for consents, knowing which owners have consented to electronic voting. And I would also put it in the unit file so that you have it in two different places, so that it's easy for you to go back and verify which owners have consented to electronic mailing.
Can I
But
take that question that just came on because it doesn't require an attorney's uh, the one about associations with more than 25 units because people get confused about the term portal and website quite often.
sure, sure.
Yeah, it suffices. Yes, a portal. The word portal just means it's the login portion. Lisa alluded to the private side earlier, the side that only owners, members will see. That's essentially a portal, but people use the word website that's synonymous. So if your management company provides the portal housing your documents, that counts. But just like we both said earlier, your association should also maintain your own set of digital records just in case you have a falling out with that management company. You want to be able to get your records access nice and easily.
Yeah, when I say website, I do mean portal or something that's available to people in an
Right.
electronic format. And it can be on your management company, it can be, with housed by another vendor. And again, when you're working with any of those entities, you want to make sure that your contract says that the data that's on the site, because you don't
Yeah.
own those sites. They own the site or they own the portal. You want to make sure that the data on that site can be easily transferred to another site.
Right.
Um, so let's see.
And while Lisa's looking, they're inexpensive things. If you're a smaller condo, for 200 or 300 bucks, you can go buy a little desktop Epson scanner that's sheet fed, and you can digitize your documents right away, and save them that way too as a backup. So there are very inexpensive ways to save your own records as a
Okay, so
backup.
I want to kind of conclude, or we have a few more questions, but there's a lot of questions about email addresses.
Mhm.
So email, that's the bane of our existence. I mean, it's been fabulously
Yeah,
convenient, but it's
it's a
from
job
our
now.
perspective, from a record keeping perspective, it is a tremendous burden. So there are cases and there are declaratory statements issued by Department of Business and Professional Regulation saying that certain emails constitute official records and they have to be made available for inspection by owners upon request. What does that mean? That means that somebody's got to be responsible for archiving these emails, and there's got to be a way for you to be able to sort through those emails to find records that are responsive to the request. But then there may be redactions that are required because some of the information on the emails may not be subject to inspection. So the general rule is this: if you're emailing your directors, and you're using your own email addresses, Gmail, Hotmail, whatever, AOL, and you're just emailing each other, did the pool guy show up yesterday? Or did the manager follow up with this one? Or back, forth, whatever, all different things.
Right.
But you're not including your manager and you're not including any vendors. As of now, those are considered private emails and they're not subject to inspection. Here are the changes. Because you want, obviously, if the pool guy showed up yesterday or did the manager follow up on that thing yesterday, a lot of times you're including your manager or staff members in these emails because you want them to participate in the conversation. At that point, those emails now become official records, official records communications that become available for inspection. So, and also if you create a site, let's just say Happy Lane Condo. So Lisa President at Happy Lane Condo, there's a very big argument that those are official email addresses for the association, and therefore they become official records that are subject to inspection. But if you did President Condo at hotmail.com, or I think it's hotmail.net, but whatever, then I can still consider that a personal email, and it has nothing to do with the association. You're just creating a brand new email address for your own internal purposes so that it's easier for you to find the stuff that relates to association as opposed to, your family and your friends and all your other things. So this is a really difficult issue that has been problematic with respect to the DBPR and will continue to be problematic with respect to the DBPR. And I know that there are smart, computer-oriented people out there that someone's going to develop an AI program that's going to archive and organize all of these documents and
It exists.
also redact the documents for you. So whoever
Yeah.
creates that, you can attribute it to me, but I don't need any financial remuneration for it.
I have a question. I have a question. Where is Happy Land Condo? I want to live there.
So
Does
do
it
I
exist? Does
actually.
it exist?
Um, uh, so a little easy question. So, uh, can a condo use its regular CPA who handles the books to do the year-end accounting? No, you need an independent accountant to do an audit or to do a higher level of financial reporting. If you're just doing a statement of receipts and expenditures, so if your budget is less than $150,000, yes, your regular accountant or your regular bookkeeping company can do it.
Hey, before
And
you go, I know you have to head out, but before you go, do text messages fall into the same category as emails?
Oh, they're going to. I mean, I have not personally experienced that, but I'm sure it's coming. I'm sure it's coming.
Okay.
And I mean, text messaging is a very, very convenient way. Hey, did they show up on time? What time do I need to be there? But for like substantive items, text messaging is not really an effective means of communication because I've tried to find ways to archive it and we've been through this and it's a bunch of screenshots attached to a bunch of screenshots
Yeah.
and me sitting there screenshotting all my texts and trying to email it to myself is really very, very laborious and not effective.
It'll take all day. Yeah, it'll take all day.
So yeah, I'm not looking forward to the new regulations when they get into all that kind of technology. Um, but that is something that we're going to have to deal with in the future.
Okay.
So I hope that everyone enjoyed today's presentation. We went through a lot, but I know that we go through things somewhat quickly. And after everyone has all their 1 year credit, I mean, the firm does presentations basically on a daily basis. So if you are interested in specific topics as opposed to these generalized updates, please check out our website because we do have information that really affects you and how you operate on a day-to-day basis, real time. That is not just very grandiose or amorphous type of requirements that concern specific items, how you levy fines, architectural control, enforcement, cameras, or what are your obligations with respect to cameras, all these different emotional support animals, that's the big one. So again, some of those topic items are not offered for credit purposes, although sometimes most of them do have cam credit, by the way.
Yeah. A lot of them
But
HOA as well, even though this is a condo class, but
oh, right. Remember, the HOA owners or HOA directors need to have 4 hours. It doesn't have to be all together, but 4 different classes throughout the year on issues associated with HOA operations. So I hope that you do this not only because you have to, but because you enjoy it and because you learn something and because it helps you in your operations. And with that, I say thank you.